Good morning, everyone. Super excited to be here to talk to you all about IP today. I'll give you my few caveats here in a second. My disclosures, I have none relevant to this talk. My disclosure really is that I'm not a lawyer. This talk is lawyer approved, and I have great resources for anyone who has questions that I'm unable to answer, but I'm going to do my best. So my goals with this talk, a few basic things. I want to talk about why we need IP, the four general types, the difference between patentability and freedom to operate, which I think is a very important but difficult topic, and then licensing at the end. And really what I intended to do with this is to put a lot more information on these slides that I'm going to say to you, because I want this topic, I want you to be able to take this home and look at it later if you need to. I know this may be a lot to digest or things you need to look into specifics at a later point. So let's start with that. Why do we need IP? So IP serves several purposes. It can be equity, so you can buy and sell IP. It can serve as fodder to increase the valuation or to help you with raising a funding round. And what does it do is it creates barriers to market entry, it protects your freedom to operate, and this all falls into the category of market exclusivity. And so IP really is essentially a government-granted temporary monopoly on your idea. And the reason that that exists is because innovation is expensive and it's time-consuming, and we need to incentivize it in some way. So there's four basic types of IP in the United States. There are patents, and that's probably what we're most familiar with, and those are things like processes, methods, devices, and we'll talk most about that during this presentation today. There's trademarks, which are symbols, words, things like the Nike logo. And there's copyright, which has 8 specific categories, but those are things like your journal articles, movies, and such. And then there's trade secrets, which are kind of a completely different category. These are things that are commercially viable to a company. They live with the employees. And then you see there's some interesting examples of each down here. But Coca-Cola recipe and the Google search engine are great examples of trade secrets. Patents must be filed, and we'll talk about that. However, trademark and copyright are only optionally filed, but they must be filed if you do intend to litigate. And then trade secrets, of course, are never filed and never disclosed. So looking more deeply at patents, there are 3 types. The utility patent, again, probably what we're most familiar with. These are things that are processes, machines, or improvements on any previous versions of these. We'll talk about the data on the right, but design patents are things like vehicle shapes, food packaging, computer icons. Those are more artistic style things. And then plant patents are exactly what they sound like. These are new biological processes or creations such as the Honeycrisp apple. But the key takeaway to this is that there are 3 fundamental things that are required for your patentability. And it's that something is able to be used, meaning that it's not just a theory, it's new or novel, and it is non-obvious. And just to highlight this data on the right, you can just see that over 90% of patents submitted and granted by the USPTO are utility type. Design take up a much smaller portion, and then plant is a very small fraction. So let's talk a little bit about the patent submission process. I'm just going to highlight provisionals first. So provisional patents they're not patents, and I want to highlight that. They're not patents. They're relatively inexpensive, they're easy to submit. It can be anything. You can write up a paragraph of your creation and submit that. No one's going to review it. You do not need claims. And it essentially expires after 12 months if you don't convert this to a full utility patent. They will never be published. No one will ever see it. The purpose of this is just to draw your line in the sand with your filing date. That's it. So if you don't convert it, like I said, 12 months, it's gone. If you look at the right, I pulled some data from 2022 patent filings. Provisionals make up about 19% of submissions, so that would kind of lead you to think that maybe a third of utility patents are originally submitted as provisional patents. I would probably wager that that is much, much lower, as in a lot of provisionals probably are not converted. Now to talk about the full utility patent. Now this is a much larger venture. So the cost is much greater. It's about $1,500 for the submission itself, plus or minus additional fees, depending on how many terms and things are in your patent. And then it's on average about $20,000 if you want to use law firm assistance. Now, looking at the data on the right, I was able to find a small study that looked at patent submissions in 2021. It was just a month sample set. 99% of these submissions were all submitted with attorney assistance. And if you look at the representation versus no representation, as you might expect, those from larger companies with attorney representation had a much greater success rate than those trying to be filed by an individual or from a small company. Now, the contents of the full utility patent submission are something we're probably very familiar with. You have an abstract background, then you also have the description of the invention, but you have claims. And claims are really the legal backbone of your patent and are what is most important in your submission. And we'll kind of highlight that a little bit more as we go along and see why this is so important. So I'll speak just quickly on prior art, and I will read you the USPTO's very cut and dry definition. It's references or documents which may be used to determine novelty and or non-obviousness of claimed subject matter in a patent application. So I'll give you my interpretation of that, and it's how close prior patents but also publications are to your idea and the specificity of your claims. So this essentially means how close is your idea to anything that's ever been published in humanity for all of time. That's a little bit of a high bar to reach. So how do you search for patents? There's a couple references I put here. These are all straight off of the USPTO's website. So the USPTO has their own search area. It's PPubs. There's Google Patents, which is pretty good, but you may find that there's some missing content there. There's also a whole bunch of other references that I pulled from the USPTO that I listed here as well. There are paid searches to help you, and so the USPTO offers one for about $500. And then you can also use a law firm to do your searching as well, and that can run between $1,000 and $3,000. Now, I just want to go back to the idea that prior art is literally anything that's ever been published by all of humanity. And so this process is not foolproof. It is simply a de-risking process, and that is something that we talk a lot about in by design, is trying to remove as much risk as possible, because you may be able to get your idea through the USPTO, but at the end of the day, you don't want your competitors to be dredging something that you didn't find further down the line and invalidate your work. So I'm going to go on to the topic of patentability versus freedom to operate. And for me, this was a little bit challenging to understand when I first learned about this topic. And so I want to go through a pretty common example. And then it's a little confusing at first, but I promise it'll be more clear when I get done with it. So patentability is what we just talked about. So the question of, is something real? So not just a theory. And are your claims new and are they non-obvious? But freedom to operate is really the question of, can I make this without getting sued? So we're going to go through an example, and I'm sure a lot of folks in this room have seen this example before. So if we look at the prior body of art, that's up on your top left, so you can see that in existence, there's already A plus B, C, and A, C, and D. And I'll give a caveat. I'm going to ask you to raise your hands in a second for a survey. And then your invention is A plus B plus C. So comparing that to the body of prior art, who here thinks that this is patentable? Just by a show of hands. Okay. A few people think it's patentable. How many people think it's not patentable? Show of hands. Okay. Less. Okay. I agree. Yes, this is patentable because your creation of A plus B plus C is novel. There has been no creation of all three of these components together before. Now, if we look at the relevant claims, the question is, do we have freedom to operate? So you have A plus B plus C. All relevant claims are A plus B. Who here thinks you have freedom to operate, as in you will not get sued when you make this? Show of hands. Okay. Who thinks you're going to get sued? You're going to get sued. That's correct. So I know this is a little bit confusing, but I gave it something that might be a little bit more understandable. So let's say your device is an X-ray that revolves around a table and has a cancer-shooting laser on it. Now, the body of prior art has things like an X-ray that revolves around a table, sounds like a CT scanner. Maybe you also see that there is a cancer-shooting laser, and there's an X-ray and a cancer-shooting laser combination, but you don't see your combination, which is A plus B plus C. So that is patentable. Now, if we look at all prior art, we see that there is an X-ray that revolves around a table, and that's a CT scanner. So can you make your device, which is essentially a CT scanner with an attached laser? You can, but the companies that own the IP on CTs have the right to sue you. They have the right to have their own technology licensed, and you must pay them for that. So where do you take this? And it's how do you actually write your claims in your IP? And it's a fine line. So if it's too narrow, you're going to leave room for copycats, meaning that people can write around you. You can't be ultra specific in your claims. But if it's too broad, you actually won't be able to get it through either, in that either it will overlap with other material, or it's just going to be obvious. So it's a fine line that we have to walk. The last topic I'm going to touch on is licensing. And the reason I want to bring this up is because I want to make the point, I don't want you to be discouraged if you are not the first of 190 billion people to have an idea. Because there are many ways to make companies or to make an idea to come to life without being the first to come up with it. And so I listed a few examples here of companies that do license or sell. And so there first are SPACs, and these are special purpose acquisition companies. These companies purchase up IP with the intention of creating companies and creating products. There are university TTOs, which are the tech transfer offices, and that's probably what we're a little bit more familiar with. Those groups, they will partially own your IP that you create at a university, but you can also buy from them, different universities or your own, buy or license IP. They also have other services too, which you may not be familiar with. They usually will have business advisors, legal advice, and then some even have funding opportunities. There are other things like standard essential patents, and I just mentioned this as an example of a widely licensed patent material. So these are things like the USB port, or rather the USB technology. And these are licensed widely by computer manufacturers, cell phone manufacturers every day. And then, of course, there's non-practicing entities, which, depending on if you like them or not, they may get the nickname patent trolls. And these are people who purchase IP, usually from failing companies, and they will then litigate others for the purposes of just profit generation. So good and bad examples. All right, the things I want you to take away from this talk today is that patents serve the function of being a government-granted temporary monopoly. A provisional patent is not a simple and cheap patent. It is only existing for the purposes of establishing a filing date in a first-to-file system. The claims are the legal backbone of your patent. And then patentability is not automatic freedom to operate. And then lastly, if you believe in an idea, you should at least consider licensing it. Thank you.